For personal bankruptcies, people, when they schedule their appointment, they usually know they need to do something about their bills, and they pretty much probably have already made a decision to file. So I get some basic financial information from them in the initial consultation, what they earn, what their living expenses are, a list of their major assets and what the values of those assets are. Most people will protect all their assets in a Chapter 7 bankruptcy. The only exception to that is are assets that have been pledged as collateral on a loan. Those you have to deal with the creditor about. So I obtain this information. It takes approximately a half an hour, and then I explain what we do and what the expectations are from the client. They have to attend and receive a certificate of attendance at a credit counseling course. That's true of anybody who files a personal bankruptcy in the country. So we explain that process to them. It takes roughly a half an hour with that entity. And then I explain what we do when we receive their information. We prepare this petition. It'll be probably 50 pages long. They have to sign it in 9 different places, review it for accuracy because they're signing it under penalty of perjury. I give them some general rules about bankruptcy, what they can and cannot do, and then explain that they do have to attend one hearing. The hearings for Sheboygan County are held, for people who reside in Sheboygan County, are held in Milwaukee at the federal courthouse in downtown Milwaukee. Those hearings are usually about 30 days after the filing of the petition. If you live in Calumet or Manitowoc counties, your hearing would be held up in Green Bay. And it's also always roughly 30 days after you file your petition. The hearings are run by an attorney hired by the bankruptcy court. He or she is called a bankruptcy trustee. Their job is to review your petition for legal correctness, which they will have already done prior to the hearing, and then to run that hearing and ask people questions under oath. Everything at the hearing is tape recorded. The hearings are scheduled for 4 cases per half hour. They normally start at 9 o'clock in the morning and they're done at 3 o'clock in the afternoon. So each half hour there's a new batch of 4 cases. If their hearings are scheduled at 11:30, for instance, they have to get to the hearing site in time for their hearing. They don't have to be there all day. When their hearing's concluded, they're free to go. The hearings are not meant to torture anybody or embarrass them. The trustee is focused mostly on property, and they're looking for people who have more property than they can protect under the various statutes. They usually don't find any available property, but that's the focus of their questions. So the actual hearing itself, the testimony part of it takes about 6 or so minutes. It may seem longer to the client, but that's how quickly it goes. Then they're excused after the hearing. About 60 days after that hearing, the bankruptcy court closes their case and sends all the creditors and the client an order signed by the judge that discharges all their debt. It's called a discharge order, and then that concludes their case. We think we do a very thorough job on bankruptcy cases. We aren't a bankruptcy mill, so to speak, where you have a high volume of clients coming in, and those firms that do focus strictly on bankruptcy, I think they don't give the client as thorough of a representation as we do. We explain every process along the way. We have a lot of contact with our clients, let them know what's going on, answer their questions. We're very responsive to our clients' questions. We get back to them right away. We deal with creditor questions as well, so they're not left in the lurch wondering, okay, what's going on with my case? We have a lot of communication with our clients, and I think we look at them as people, not just a file that's flowing through the office. So I think that's what sets us apart. So if you're looking for a lawyer to represent you in a bankruptcy, give us a call. We have the free initial consultation. It doesn't cost you anything. Every meeting we have with clients is confidential. Nobody will know that you met with us. And give us a call. Our number is 920-451-6100.